And that was it. That was Begbie's story. What indeed could one do? Just stand back and watch and try not to get involved. Begbie didn't do drugs either. He just did people. That's what he got off on. His own sensory addiction.
The basic study of tort law is usually approached in 3 units. Each one is described by the culpability state of the defendant. The first is intent, the second is negligence, and the third is strict liability. You can think about intent as the simple case of punches being thrown in a bar fight. Negligence is usually associated with something like a car accident, and strict liability is a zero-fault state. We'll do more with that later. We begin our study of torts with intentional torts. These are civil wrongs that the defendant intended to do. When we study intent, it's important to remember that intent is a subjective test. That means that the person being tested is tested subjectively. We look into the mind of the person to see whether the culpability state is there. With intent, we're looking for intent in the mind of the defendant. While we study tort law in discrete states of culpability, that's not really how culpability works. In reality, there's a spectrum of culpability states, an infinite number of points between intent, negligence, and strict liability. One that we saw was knowledge and substantial certainty. That is, the defendant had knowledge of facts and a substantial certainty in the result. That fell just a little bit short of pure subjective intent. Recklessness is another common culpability state and occurs about halfway between intent and negligence. Those states might be called intent minus, that is less than intent, but there are also intent plus states, more intense requirements of proof, such as double duty intent, which requires a plaintiff to prove that the defendant intended not only a volitional act, but also the injury that resulted from it. And that's very hard to do. Another way of thinking about culpability is on a timeline. Every case has a timeline, a series of events involving 2 parties, the defendant and the plaintiff. Everything that happens in the case happens on that timeline. An intentional tort starts with the defendant's forming in his or her own mind the thought to act, and then there's evidence of some physical act on the part of the defendant. Subsequently, there is an impact on the plaintiff resulting from that physical action by the defendant. For example, in battery, we look for offensive contact on the plaintiff, and that's required for there to be a tort. After that impact are all the consequences, all the injuries that the plaintiff suffers. When we test the culpability of the defendant, we can look for the defendant's intent at different points along the timeline. So, some torts might look farther down the timeline. As we saw, IIED looked to see whether the defendant intended the harm that the plaintiff suffered, and that we call double duty intent, a very demanding proof. Other torts look for just intention as to some threshold, the way battery looks for intent as to offensive contact. Here's one more conception of intentional tort that might be useful going forward. Imagine that all intentional torts are part of the same family. That is, they're all related by intent. Battery, assault, false imprisonment, fraud, all those torts we studied are special cases of intent, evolved tests from common law experience. But in that negative space, binding them all together is what we call prima facie tort. A prima facie tort is something that's a civil wrong on its face. The experience of common law hasn't yet given us a test for it, but we trust judges to know the difference between right and wrong and figure out when there is an intentional civil wrong that's not otherwise classified. So let's get back to our movie. This is 1996's Trainspotting, directed by Danny Boyle. In this scene, Begbie, played by Robert Carlyle, starts a bar fight, and this is one of the top bar fight scenes in Hollywood history. The voiceover is Ewan McGregor as Mark Renton.
Begbie didn't do drugs either. He just did people. That's what he got off on. His own sensory addiction.
That lassie got glassed and no leaves here till we find out what did it. Who the f*** are you? Yes!
Okay, let's roll that back to when Begbie comes down the stairs.
That lassie got glassed and no leaves here till we find out what did it. Who the f*** are you?
We don't know exactly when Begbie decided to hit this guy. Intent is subjective, so it first forms in the mind of the subject. But in a moment, we'll see the first volitional act that evidences subjective intent. To batter.
Yes!
Here comes intentional offensive contact. Begbie might have intended for this plaintiff to feel pain and suffering now and for weeks to come, but it's not necessary to prove that. The plaintiff only has to prove intent as to the offensive contact. Whatever consequential harms the plaintiff suffers from that point on goes to the damages analysis, not the liability analysis. Okay, let's go farther back this time, to when Begbie first threw the beer glass. When Begbie throws the glass, he does not know that the woman is standing below. His act is therefore volitional, that is, he intends to throw the glass, but that intent does not reach offensive contact against the woman below, which means she cannot prove battery. There is, however, an argument that if the bar is very crowded, and Begbie knows that the bar is crowded, then he also knows that throwing the glass over the railing is substantially certain to result in an offensive contact against someone below. One could argue, then, that Begbie has knowledge to a substantial certainty that if he throws the glass over the railing, it will hit someone below, and that might be sufficient to establish intent. At the very least, though, Begbie is reckless, so he will be held liable in any event.
What indeed could one do? Just stand back and watch and try not to get involved. Begbie didn't do drugs either. He just did people. That's what he got off on. His own sensory addiction.
That lassie got glassed and no leaves here till we find out what did it. Who the f*** are you? Yeah!